Before we jump into today's courtroom chaos, get ready because this episode is packed with some of the most stubborn sovereign citizen arguments you'll ever hear. In this video, 4 different defendants walk into courtrooms thinking they've discovered legal loopholes that somehow make them immune to the law. Instead, they're about to run headfirst into 4 judges who have absolutely no patience for these arguments. From confusing legal jargon to classic right-to-travel claims, every single case here shows what happens when internet law collides with actual courtroom procedure. The question is, will any of them realize their mistake before it's too late? Or will they double down? Let's find out.
State your name, sir.
Mr. Fox, for the court charge possession of paraphernalia and a no valid driver's license. You understand the charges?
Understand what you're charged with?
No? No. She doesn't understand. Allegedly, you had methamphetamine on or about your person, and allegedly, it may have been contained within something that qualifies, aka a clear plastic bag, that qualifies as paraphernalia in the state of Florida. And allegedly, you were operating a motor vehicle without allegedly having a driver's license.
Right away, you can see something that judges deal with constantly when defendants represent themselves: confusion between understanding a charge and admitting guilt. The judge here isn't asking whether the defendant committed the crime. He's simply asking whether he understands what the charges are. That's a basic procedural step in nearly every criminal arraignment. But sovereign citizen ideology often encourages people to resist even simple courtroom questions, believing that refusing to acknowledge charges somehow undermines the court's authority. In reality, all it does is slow the process down and frustrate the judge. And as you're about to see, patience in a courtroom only lasts so long.
You understand that?
I understand the driver's license, yes, sir.
Okay, well,
Possession.
I didn't say it was yours. Did I say it was yours? I said you've been charged with.
Right.
Nobody's asking if you did it. I'm just asking if you understand what the charge is. Yes or no?
No, sir.
Okay, we'll bring you back tomorrow when you understand.
I was hoping I'm not from this state. This county. If I can just resolve everything today.
You got a parole hold. You wouldn't get out anyway.
You got nowhere to go, man. So, do you understand the charges against you or not?
I understand they charging me with it, yes, sir.
That's all you got. See how easy that is? I don't know why do we have to go back and forth?
It's not easy when you're in my shoes, sir.
It's easy. It's a yes or no question. Do you understand?
I don't agree to the
Nobody's
contract.
asking you to admit to anything. I just need to make sure you understand the charge.
I'm a private citizen, sir.
I'm shocked.
Under UCC folks.
Oh, UCC? Oh, I love it. A sovereign. Golly Moses, I love those.
Now this is a classic sovereign citizen talking point: the Uniform Commercial Code, or UCC. Online communities often promote the idea that the UCC somehow overrides criminal law or allows people to escape government authority. But in reality, the UCC is simply a set of commercial regulations used to standardize business transactions between companies. It has absolutely nothing to do with criminal charges, driver's licenses, or traffic enforcement. Judges hear this argument constantly, and most of them respond exactly like this one: half amused, half exhausted. Because from the court's perspective, these arguments aren't just incorrect, they're completely irrelevant to the case being heard.
Mr. Fox, crap in one hand, hope in the other, and see if that helps. Onset at 5,000 on meth, 1,000 paraphernalia, 500 on the driver's license, which oddly enough, the Supreme Court said you do need to drive. Court date is February the 17th at 9 o'clock, but you're not going anywhere because you got that probate or that parole.
Step to your right to the T.
Mr. Fox, when you sue me, make sure you spell it with 2 N's. I want to make sure the AG's office gets involved.
You don't have to worry about that, sir. I'm peaceful.
Sign where the light is for your copy of that. Next.
It's off the 11 o'clock calendar. Mr. Calzada, could you please turn on your video for me? Yeah, hold on one second.
All right, good morning, Mr. Calzada. You're here for arraignment, so could you please tell me your full legal name?
I don't know how that has anything to do with a case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you
Here
please
I
tell
am.
me? Well,
I'm here
please tell me,
physically present, right?
Mr. Calzada, could you please? What is your first name?
My first name? Well,
Mhm.
it could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Laurie, you'll have law enforcement standing by. All right.
Well, there you are.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal Court for arraignment.
I don't even consent to that.
This moment highlights another common misunderstanding about court procedure. When a judge asks someone to confirm their name during arraignment, it's not some kind of trick question or legal trap. Courts need to verify identity to ensure that the correct person is responding to the correct charges. Refusing to confirm basic identifying information doesn't protect you. It simply prevents the hearing from moving forward. And when that happens, the judge usually does exactly what we see here. Postpone the hearing and require the defendant to appear in person, often with law enforcement present. In other words, resisting simple questions rarely helps anyone in court.
I didn't even consent to. I was gonna go there today, and you guys were all doing Snohomish County prisoners. Pretty busy, huh? The sheriff even said it's pretty busy. The court has to file a 1099-C. How you file a 1099-C for that bond? You don't need voter approval for that, don't you? Those bonds. How much are the bonds?
Mr. Calzada, I'm going to set this to December 31st at 1:30 in the Bothell Municipal Court in person. You will need to be there for arraignment, okay? So I will see you in person at the Bothell Municipal Court at that time, all right?
Looks like there's no free will then.
So
what am I doing here then? Hold on, what am I doing here?
well, right now you are not responding to my questions. So
Well, you're
I'm
not
gonna have you
responding to any I don't have a problem of answering any of your questions, but I have a couple questions first. I have to understand too. I don't understand what's going on. I don't know everything. I'm not perfect.
come in person so that we can be sure that you understand what's
All
going on.
right, great. I'm glad. It's definitely implied, isn't it? It's not expressed. It's implied.
December 31st at 1:30 in person.
December 31st at 1:30, I'll be there.
Very good. We'll see you then.
Ms. Soap, you're here on the Martin matter, correct?
Yes, Judge.
Conversation outside. All right, today is the date and time set for a hearing in this matter with regard to a bond violation. This is case 242448SM. Abel versus Eric Martin. Everybody hear me?
Yes. Good morning, Judge Donna Silva on behalf of the people, PA 7439.
Morning, Your Honor. James Kazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
Your Honor, I'm making a motion to withdraw. I've had contact Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I can adequately represent him, Your Honor. So I'm asking to withdraw.
All right, your motion to withdraw is granted. Mr. Martin, would you like a different court appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's misstating, making false statements here talking about there's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just didn't want to do his job. That's clear what he made of me, so.
Mr. Martin, I have found Mr. Gazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court, and I found him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin.
What you're seeing here is a judge trying to maintain courtroom decorum. Courts operate under strict rules about respect and professionalism, especially when it comes to interactions between defendants, attorneys, and the judge. When someone begins insulting their own attorney or making personal attacks, the judge has the authority to shut that behavior down immediately and even issue contempt sanctions if it continues. Judges also rely heavily on the credibility of attorneys who regularly appear before them, which is why the judge is defending the attorney's professionalism here. From the bench's perspective, the courtroom isn't a debate stage or talk show. It's a place where legal arguments must stay focused and respectful.
Done with everything you keep doing, all your little negative comments, things that you want to say about people. You think you're the smartest person in the room and that you have some sort of special juris doctorate, I guess, from somewhere. I don't know, but you don't have the first clue when it comes to things, and you talk about that. And so Mr. Gazicki is saying that he's trying to talk to you about actual legal defenses, and you're trying to bring up some kind of other stuff. And so I'm going to grant his motion. All I asked you was this. I didn't ask you to give me a commentary about Mr. Gazicki or what you think he can do, because I've always seen him to do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney, or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering the questions.
Yep, one other attorney, but I want to state also that if it was recorded, we would say it would support my allegations.
Boom, time out. No, not hearing it. The question is this: do you want another court-appointed attorney? So you're either going to say yes, court-appointed attorney, or represent yourself. What is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you like. Or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
That's another pointed one, but without.
All right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. And the individual who is here is your attorney during your trial. You seem to get along pretty well with him. You want me to reach out to see if he's available?
I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. I won't say for the most part, maybe for the most part, but there's some things he didn't do either. He should have. He didn't raise my right to travel defense. So
yes or no? Yes or no? Is he somebody that you think you can get that you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint, reach out and see if we can see if he's available. So let's appoint.
But now, Slayton, I have some questions for you before we move forward.
All right. So we're going to set that. We're going to set that for a hearing date, and we'll see you then.
Hold on.
Okay. Good afternoon. My name is David Heiss. I'm an attorney magistrate. We are scheduled for an informal hearing in two different cases that arise out of one citation. And those two cases are both entitled The People of the City of Battle Creek versus Roosevelt LaShawn Williams. Is that your name, sir?
That is my name.
Basically, what happens is you were issued one citation. It had two violations listed on it, so it became two different cases, one with an A and one with a B at the end. But we have one informal hearing scheduled for both of those cases because they both arise out of the same transaction, so to speak. And I guess, Officer Kellums, is there anything before I begin?
No, sir.
All right. Mr. Williams, you're here because you were issued a citation. And in each of those two cases, so for each of those violations, you have three possible responses to the citation. You can first admit responsibility, be assessed the fines and costs, and be done with it. You could, as a second option, admit responsibility with an explanation, hoping that the explanation would cause the court to decrease the fines and costs a little bit. Or you can deny responsibility and have your hearing. It's my understanding that as to both cases, you wished to deny responsibility. Is that correct?
That is correct.
Okay. Well, here's how the hearing works. First of all, I guess I should read the citation. In the case ending with the letter A, it's alleged that back on November 19th of 2024, you were over at Fountain Street near Meacham Avenue in the city of Battle Creek, and you were issued a citation for not being able to provide a proof of insurance. This is a civil infraction. If you were found responsible, all other things being equal, the court would assess $125 fines, costs, and fees. It is a 0-point ticket. And in the second case that ends with the letter B, that same date, time, and place, you were issued a citation for having an expired registration plate. That is also a civil infraction. It is also a 0-point civil infraction. If you were found responsible, all other things being equal, the court would assess $110 fines, costs, and fees. So first question, is that the ticket or the two cases that you thought you were appearing about, Mr. Williams?
It is.
Okay, and same question to you, Officer Kellums?
Yes, sir.
Very good. In every civil case, the plaintiff has the burden of proof, and in a case like this, that burden of proof is called by a preponderance of evidence.
Only question I have is, will the laws of the U.S. Supreme Court be applicable? And the federal statutes and definitions of motor vehicle and automobile be applicable in this proceeding?
They are the state of Michigan laws that will be applicable.
Okay. The other question is, are you already not bound by U.S. Supreme Court rulings?
Every court is bound by relevant Supreme Court rulings.
Okay. All right.
I'm not sure why you're asking that, but that's okay. All right. So if you would both raise your right hands. Very good. All right, Officer Kellums, if you would begin, please.
So on November 19th, 2024, I was on patrol for the Battle Creek Police Department. When I observed the vehicle that Mr. Roosevelt was driving, I observed that it had expired tags on the vehicle. I then conducted a traffic stop on Fountain Street near Meacham Ave. Found Mr. Williams to be driving the vehicle, where I issued him the citations. When speaking with Mr. Williams, he could not provide insurance, and his tags were expired.
Okay. Do you happen to know when they expired?
I do not off the top of my head, sir.
Okay. What made you think they were expired? The wrong color and the wrong year on the plate itself, or something?
Yes, sir. Yes, sir.
All right. Did Mr. Williams say anything to you during the stop about having insurance or not having insurance, or anything about the tags on the plates, anything like that?
He informed me that he did not have to have insurance due to he was traveling, and to drive a vehicle, you have to have insurance. Something regarding Supreme Court. That's about all he said.
Okay. All right. Do you want me to consider anything else at this point, Officer Kellums?
No, sir.
Okay, Mr. Williams, could you hear Officer Kellums' testimony?
Yes, I heard his testimony.
Very good. Thank you for your patience. What do I need to know, sir?
Okay, I did inform Officer Kelly that I am not operating a motor vehicle, but I am operating an automobile. I did inform Officer Kelly of the ruling of Rodriguez v. Ray Donovan, U.S. Department of Labor, 769 Federal 2nd, 1344, where the U.S. Supreme Court's decision has ruled that all codes, rules, and regulations are for government authorities only and not for human creators. In accordance with God laws, all codes, rules, and regulations are unconstitutional and lacking due process.
All right, I'm going to interrupt you just for a second. Are you telling me that a case at 769 Fed 2nd, 1344 indicates that all laws are unconstitutional?
All codes, rules, and regulations. Yes, sir. Rodriguez v. Ray Donovan. And if I'm not mistaken.
And you said that was Department of what?
U.S. Department of Labor.
Okay, U.S. Department of Labor doesn't publish decisions in the Fed 2nd. Can you tell me a little bit more about the case? What was that issue in the case?
It was regarding what we're discussing here, the requirements of a driver's license and the need when it's required to have one, stating that when you're not operating commerce, to which I informed the officer that I am not operating commerce as stated in USC 18 USCA 31 paragraph A6, states that a motor vehicle, the term of motor vehicle meaning every description of carriage, conveyance, propelled or drawn or mechanical power and used for commercial purposes. This is what Title 18 USCA Section 31A6 states or defines as a motor vehicle, to which I am not operating in commerce.
Here we encounter one of the most persistent sovereign citizen claims: the belief that driving laws only apply to commercial vehicles and that private citizens have an unlimited right to travel without licenses or registration. While it's true that Americans have a constitutional right to travel between states, courts have consistently ruled that operating a motor vehicle on public roads is a regulated activity. That means states can require driver's licenses, insurance, and registration for safety reasons. The distinction is simple. You have the right to move freely, but that doesn't mean you can operate any vehicle however you want. And judges across the country have upheld that interpretation for decades.
I'm not using...
For the purposes of that particular chapter of the United States Code, it would not control what happens in terms of the Michigan legislature defining in Chapter 257 what a motor vehicle is, and an automobile under Michigan law is a motor vehicle. But okay, continue.
A motor vehicle, which is described as anything, even by the Michigan compliance statute of 751, which you just stated, is determined as something that's transporting goods, which I am not transporting goods.
I understand your position, and I can tell you that that position doesn't happen to be legally correct. But go ahead.
So you're basically stating that there's a misinterpretation of what's in black and white?
No, I'm telling you that you have misinterpreted the application of 18 USC 31A6 and 769 F second or Fed 2nd 1344.
Okay, but, well, I see what
I've heard your argument.
So there will be no further arguments because I see that you're not going to agree to, because like I said, when I've given it to you, the cases where they're like Shapiro v. Thompson, where the U.S. Supreme Court has said that this driver license is not a requirement, that this is, you're trying to convert a right into a privilege, to which is covered by Article 1, Section 8.
I'll ask you this. Is that right, the right to travel?
That is a right to travel, convey, however you want it, by the U.S. Constitution.
What you just told me was that somehow but regardless, am trying to convert a right into a privilege. Now, the question I have for you is, what right has been converted to a privilege?
My right to freely travel unencumbered and unfettered.
I will ask you this. How is your right to travel removed by receiving the citation?
By trying to require me to have a license to operate a automobile, which is my private vehicle.
Okay. All right. Is there anything else you want me to consider?
No, sir.
I can tell you this. The Michigan motor vehicle laws, including the laws that require you to carry insurance, that require your vehicle to be registered, and require that registration to be current, do not run in violation of any right to travel under the Constitution or the United States Supreme Court decision that you have cited. In fact, Michigan courts have held that essentially the right to travel means the right for you to move from A to B, not the right for you to travel from A to B under your most convenient way. So you could walk from point A to B all you wanted. You could take a taxi or an Uber or a plane or a train or a bus. But if you wish to travel by using a motor vehicle, the Michigan laws are applicable and don't unconstitutionally interfere with the right to travel. It doesn't convert the right to travel into a privilege. You are not denied the right to travel. You may be denied the privilege of traveling via a motor vehicle that you are operating. So,
okay, so
that is what the law says, and that's what I'm finding. Is there anything else you want me to consider about that finding?
Shuttleworth v. Birmingham, U.S. 147. Do you mind telling me what the U.S. Supreme Court ruled in that?
U.S. 147 doesn't give me the site of a case. That's an incomplete site of a case. Okay.
It was shuttle.
And if you wish me to consider the case, why don't you tell me what was at issue in the case and what year it was decided?
I said Shuttleworth v. Birmingham, U.S. 147, 1969, where it says
U.S. 147 is not a complete cite. The way you cite to a case is by name and then volume number and then the name of the publication and then the page number. So, for instance, when you said 769 Fed 2nd 1344, what that means is volume 769 of a book or volumes called the Federal Reporter, 2nd edition, at page 1344. So when you're asking me about this most recent case that you've talked about, what you said was US 147, I think. That's not the citation to a case. So you're going to have to tell me more about that case. Who were the parties to that case, and what issue was before the Supreme Court in that case?
Okay, so you didn't hear me cite the name of Shuttleworth v. Birmingham?
I heard you say the name. That doesn't tell me what. That's not a complete cite of the case.
All right. Do you not have the documents that I filed when I filed to say that I want to have an informal hearing? The affidavit that writes that my
there are documents that have been scanned into the court that you dropped off.
Okay.
So from those documents, why don't you tell me the proper citation for Shuttle versus Birmingham?
Okay. Traffic infractions are not crimes, blah, blah, blah. Person faced with... Okay.
Right. Traffic infractions are not crimes. That's absolutely correct. They are civil infractions.
I was reading from a different case, but the case that I'm citing from states that no license necessary to drive an automobile on public highways, streets, no license is necessary. The word operator should not include any person who solely transport his own property and who transport no persons or property for hire.
Where's that citation from?
Okay, I just appeal it, and that way I can make sure all citations are.
It's fine. I mean, the idea is I can't look up what you're telling me, right? Without a proper citation. So you can read, for all I know, and I don't mean this, I'm using a farcical example. For all I know, you're quoting the municipal court in Honolulu, Hawaii, which has no jurisdiction over Michigan.
It's
right?
understandable.
I don't know.
So I would cite Payne v. Massey, 19196 Southwest 2nd, 493, Texas, 273.
Okay. Well, and I can tell you that Texas law, a court interpreting Texas law, that decision wouldn't be controlling on a Michigan court. But that's fine. I think I understand where you're going. If you want, I don't need to consider anything else. I'm just asking you, is there anything else you want to present to me?
If you're not going to consider anything else, then we can proceed on to your ruling, of which I know you're going to find. So, and like you said, I have a right to appeal it. So
yeah, and I'm willing to listen. if you're going to quote something, I need to know what you're quoting, and I need a proper citation so I can look it up myself, right? Because otherwise people could just run around quoting Mickey Mouse if they wanted.
Right. Okay. So
nothing against you. So the question to you is, what else do you want me to consider at this point that you haven't yet told me?
Okay, Zobel v. Williams, 457 U.S. 55.
And why are you citing that case? What is it telling me?
Because it states that, let me see, the above, blah, 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 to travel unencumbered and fettered on common public way or highway, which is their right to so do.
Absolutely.
That the right to travel is constitutional protected.
Yep.
It don't.
Anything else you want me to consider?
No, sir. No, sir. No.
Okay. I have no problem telling you have the right to travel. I have no problem telling you have the constitutional right to travel. All citizens do. No doubt about that.
One question. Is there a difference between a motor vehicle and an automobile? Is there a difference?
Yes. All automobiles are motor vehicles, but not all motor vehicles are automobiles.
Okay, so is my automobile not my private, personal automobile that's not being used in commerce?
I would have no idea the use of your motor vehicle, and it's not relevant to me for the purposes of deciding whether you're responsible for these civil acts.
Okay. Well, I have nothing else for you to consider.
Well, very good. I'm letting you know the law does not make a distinction between your using the vehicle for personal reasons or you're using the vehicle for commercial reasons when your registration plate is expired and when you fail to show proof of insurance. Both of those are required.
The MCL language.
Both of those are required under Michigan law for anyone operating any motor vehicle. That's what I can tell you. So
correct.
If you're
a motor vehicle, to which I am not operating a motor vehicle, and this is what we are trying to,
I guess,
circumvent.
Yeah,
I am operating my automobile, not a motor vehicle.
I can tell you that an automobile is considered a motor vehicle under the Michigan Motor Vehicle Code, so that's fine. Is there anything else you want me to consider?
Nope.
Very good. All right. So I've listened very carefully to the evidence. I do find that it's more likely than not that when you were required to by Officer Kellums at a traffic stop show proof that your vehicle was insured, that you failed to do so, and that it is more likely that your not your operator's license, I'm sorry, the registration plates on the vehicle were expired. So I'm going to assess the $125 on the no proof of insurance case and the $110 on the expired plates case. All right. Thank you both for your time and patience. You're all set. Have a very good day.
Thank you, sir. You too.
You too.
Looking back at these 4 hearings, a clear pattern emerges. Each defendant walked into court believing they had discovered a legal argument that would completely invalidate the charges against them. But the reality of courtroom procedure is very different from what's often promoted online. Judges rely on established statutes, precedent, and clear legal definitions, not internet interpretations of constitutional law. In every case here, the court addressed the arguments directly and explained why they simply don't apply. And that's one of the biggest lessons from these hearings. Believing something is legal doesn't make it legally correct. Now we want to hear from you. Which moment surprised you the most in today's video? Do you think any of these defendants genuinely believed their arguments would work? If you found this case as unbelievable as we did, make sure to hit that like button, share this video, and subscribe to the channel for more jaw-dropping courtroom breakdowns just like this one.